Hi, and good morning. My name is Kai Jacobs, and I am the owner and founder of the South Florida Business Law Group. We help businesses when they have to go to court so they can go back to making money. Today, we're going to talk about the state of evictions in South Florida since the CDC moratorium on evictions was ended by the U.S. Supreme Court on August 26, 2021. So this morning, we have South Florida's state of residential evictions. How much time is left on the clock? On August 3 of this year, President Biden signed into law a new moratorium on residential evictions throughout the United States. It was managed through the Center for Disease Control, the CDC. Now, to be clear, this was not an outright ban on evictions. It did require a tenant to take certain actions, including the downloading and signing of a form signed under penalty of perjury, that they were suffering conditions that caused them financial hardship due to COVID. Didn't necessarily mean that they were sick or had been sick, but that they were suffering financial conditions such as loss of income, loss of hours worked, or in fact, having been sick that prevented them from being able to timely pay all of their rent. To be clear, it prevented tenants from being evicted. It did not excuse their ultimate obligation to pay rent. It was always contemplated that tenants would ultimately be responsible for paying this rent at some point in the future. But on August 26, 2021, the U.S. Supreme Court, in an opinion issued by all 9 justices, struck down the latest moratorium. The case was called Alabama Association of Realtors versus DHS. Now, to be clear, the Supreme Court didn't necessarily say that a moratorium on evictions was illegal. It was simply that the method and the means by which it was done by the president were not appropriate. The Supreme Court did make clear that Congress could, if it wanted to, impose a law that did something similar, because that was the body ultimately responsible and able to impose laws like the one that was effectively created by the president's executive order. For practical purposes, that seems like it's unlikely to happen in short order. So as we are speaking today on September 16, 2021, there is no moratorium in place preventing residential evictions on a federal level. Now, what does that mean to you as a landlord or tenant here in South Florida, and more specifically, Miami-Dade or Broward County? Well, it does mean that if you are a tenant and you have not paid the rent, you could be subject to an action for eviction. But there are options as means to avoid litigation. There are programs in both Miami-Dade and Broward County that are effectively rent assistance programs and provided the tenants and the landlords cooperate to some degree, they can avoid actions for eviction and get the rent paid. Now, in Miami-Dade County, to be clear, the county's website has made clear that eviction actions that were pending before we had our effective first lockdown after March 12th, 2020, those evictions that were scheduled to take place prior to that date will resume on November 13th. For everyone else, however, the county has received money from the federal government as part of the Emergency Rental Assistance Program, meaning that there is a pool of money available to help landlords and tenants to both get the rent paid and keep tenants in place. Under the program, qualifying tenants can receive up to 12 months in rent. They do have to meet certain income qualifications, meaning they can't earn more than 80% of what's called AMI, area median income. And what is area median income is laid out in a chart right on the county's website. There is a specific page at miamidade.gov devoted to this program. There's a very pretty chart you can take a look at, and it will tell you how much money a household has to earn or cannot earn more than in order to qualify, from one person up to 8 people in the household. In an application for rental assistance, the tenant has to be able to demonstrate that they have suffered financial hardship due to COVID. And again, it doesn't mean that the tenant or someone in the tenant's household was sick. It means that they could have lost their job. They could have had a salary reduction. They could have had a reduction in the number of hours worked, or had family members come and live with them who were sick. And all of this information is right here at www.miamidade.gov, including the forms for tenants to download and fill out. In this program, it's the tenants who actually apply for the relief. But in order to get the benefits, they're going to need the landlord's cooperation and participation. To qualify, the tenant has to be a Miami-Dade resident. The tenant has to have suffered financial hardship due to COVID. As I mentioned a few moments ago, the tenant's household can't earn more than 80% of area median income. There must be an executed lease between landlord and tenant that they can show to the county. And if the tenant is receiving subsidies under a different federal housing program, the extent of that rental assistance or other financial consideration is accounted for by the county in the application. Because there are so many programs, I'm not going to get into what each of them means, but it's on the website, and in applying, the county will sort through what these programs are, whether or not there's any change to the benefits to be received. But both landlord and tenant should be aware that if there are other federal assistance programs in place, they will be accounted for in granting benefits under this program. And well, of course, the landlord's going to have to provide a W-9 in order to receive the funds, and so that the funds are properly accounted for to the IRS. And finally, the landlord's cooperation is going to be needed because the landlord is going to have to sign off on an agreement. Now, the website doesn't specify what all the terms of the agreement are, but they do include that the landlord will not sue the tenant for eviction, and that the landlord will not sue for additional rent benefits in court. In Broward, it is also a participant in the same rental assistance program, but it has its own rules and qualifications. Similar to Dade counties, but there are some differences to be aware of. In order to receive benefits, the tenant has to be able to demonstrate to the county that he or she qualifies for unemployment, income reduction, there's been significant costs or financial hardships due to COVID. And like in Dade County, it doesn't mean that the tenant has to have been sick, but simply has to have had some adverse financial consequence somehow related to COVID. The tenant has to demonstrate that without the receipt of benefits, they suffer the risk of homelessness or housing instability. Housing instability are the exact words that appear on the Broward County website. And what they mean by that is that you're about to have the power shut off, or the water shut off, or the other things that you have to have in order to be able to live indoors. A tenant has to demonstrate an arm's length landlord-tenant relationship. In Dade County, you have to produce a lease. Here, you have to show that you're not just living in your friend's place or a family member's place, but that you actually have a proper contractual relationship with your landlord, even if it's not written down. And again, like Dade County, you have to be able to demonstrate that your income is at or below 80% of AMI. Now, in Broward County, if you get onto the Broward County website, you will see that the income requirements in Broward are just a little bit lower than they are in Dade County. So if you are a landlord and own property in each of those counties, be aware that what qualifies for assistance will be slightly different in terms of dollars earned for your tenants. Broward County has also included priority considerations for tenants whose AMI is at 50% or below, or they've been unemployed for more than 90 days, and/or they are already in an active eviction status, meaning they have been sued already. Under this program, tenants in Broward County can receive up to 12 months of rent, but they can also get up to 3 more, provided they meet certain income and situational qualifications that are spelled out on the website. When applying for benefits, the county will pay past due rent first. The 3 months going forward will only be considered after they've made payment for all past due rent. Under the Broward County program, in order to avoid the situation of what they call housing instability, the county will also pay utilities. Now, under this program, the rental payments are paid directly to the tenant, but the utility payments are paid directly to the utility company. And again, if a tenant is receiving any kind of housing subsidies, those are taken into consideration in granting benefits and determining the amount of those benefits. So where does this leave us? Well, as of August 26th of 2021, the CDC moratorium may be over, but that doesn't necessarily mean that there's going to be a flood of litigation. There are ways to avoid eviction lawsuits. And quite frankly, if a tenant qualifies for a program and can secure the landlord's cooperation, it is a very viable means to avoid litigation. But if a tenant does not qualify, actions for eviction are authorized and the clock is ticking. So with that, it's the end of our presentation. I thank you very much for attending. I'm Kai Jacobs of the South Florida Business Law Group. We help businesses when they have to go to court so they can go back to making money. If you have any questions or you need to know more information or just want a copy of this presentation, feel free to reach out to me. My email is there on the screen, kj@sflblg.com, and our office phone number is 305-768-9846.